All rise. Just to the appellate division Supreme Court First Department. Here you will first having business with the appellate division. One here, you attended, and you shall be heard. You be seated.
Welcome to the Appellate Division First Department. We have 7 hours of argument time requested, so only ask for the time that you need. We have reviewed your briefs and the records and are familiar with each of the cases. The first case is People versus A. Appellant. Okay, 3, 1, and 3. Arias versus 139 East 56th Street. Appellant. I'm sorry, what? Respondent? Okay, 3, 1, and 3. Anissa versus Martha D. is submitted. Nurez versus Morton. Appellant. 3, 1, and 3. Wilmington Trust versus Fife. Appellant. Respondent? I'm sorry, what? I'll give you 5, 1, and 3. People versus Johnson. Appellant. Four, 1, and 3. Chester versus Cleo Realty. Appellant.
4 and 2, Your Honor.
4, 2, and 4. Rwanda versus New York City Housing Authority. Appellant.
4 and 2, Your Honor.
4, 2, and 4. Polanco versus 756 Joma Food. Appellant.
4 minutes. 4 and 2.
Respondent. 4. Layton versus Seagull. Appellant.
Your Honor, 5 and 2, please. Respondent 5.
5, 2, and 5. People versus Alvarado. Appellant. It is submitted. Sangar versus 985 Bruckner Boulevard. Appellant.
Appellant 3 and 1, please.
3, 1, and 3. Sao versus Paul Lowe, and Justice Ong is recused on that matter.
Respondent 3.
5, 1, and 3. People versus Luck. Appellant.
4 and 1, please. 5.
I'm sorry, what you asked for? I'll give you 4, 1, and 5. Milosec versus Exxon Mobil. Appellant. 5, 2, and 5. Cullity versus Posner. Appellant. Respondent. I'll give you 5, 1, and 5. People versus Zaki Smith. Appellant. That is submitted. And NBC Ventures versus Marshall Jewelry is submitted. So the first case is People versus A. Go ahead.
Good afternoon, Your Honors. The fee waiver statute was designed to alleviate the disparate impact that fees and surcharges have on people just like Errol and his family. At the time of the offenses, Errol was 16 and 17. He was indigent. He was a student who had never been employed, and he was completely...
Counsel, could you address the appeal waiver in 2017?
Yes, Your Honor. So there were actually 2 appeal waivers in this case.
That's why I'm asking you to address the one in 2017.
Well, I think, and I believe that respondent actually agrees with this, you have to look at the appeal waivers in the aggregate. In this case, he had 2 oral colloquies explaining the appeal waiver and also 2 written statements. You also have to...
Why do you have to look at them in the aggregate? Why can't you just look at the appeal waiver for the one that imposed the surcharge, which was the subsequent one?
Because this adolescent was in court. He had never had a criminal conviction before.
It isn't the only issue that we're talking about is whether the surcharge is or is not appropriate. So don't we have to look to the sentence that involves the imposition of the surcharge, which is the subsequent one?
So there's one sentence with two warnings with them, and you do have to look at everything that he was told, because he was given contradicting information, and this 17-year-old is not going to be sitting there picking out from the same court the 4 different explanations of the appeal waiver, which of the information was correct. So in the first one, he was basically told, or the warning really jumbled whether or not he automatically waived his right to appeal.
So is it your position that if there was a problem with the waiver in 2014 and the 2017 waiver on its face was fine, that makes the whole thing deficient?
Well, Your Honor, as long as the court in the final waiver says, you know, this is this information right here, this is the information you believe, not the contradicting information that you were told the first time. I mean, the written waiver in the first one actually told him that he completely waived his right to appeal. And he was also told repeatedly by the court that they had no intention of convicting him of a crime. The fee waiver says over and over again that he is waiving his right to appeal his conviction. And this is an adolescent. He shouldn't be expected to understand which of the waivers and what part of the waivers were correct. So you really have to look at the aggregate. And this is somebody who had never been before a court or had been before a court in 2017 only twice. And, you know, he was an adolescent. The fee waiver was not sufficient.
Thank you.
Thank you.
May it please the court, Charles Wan for the respondent. Regardless of whether the waiver...
Counsel, if the 2014 waiver was defective, let's just assume it was, can that make the 2017 waiver, no matter what it was, invalid by itself?
No, Your Honor, because defendant received one single sentence. So both waivers should be reviewed together, and 2017, as the most recent one, should have greater effect in deciding whether deciding the validity of the waiver. And in both instances, the court told defendant that the waiver is separate and distinct from the guilty plea. And although there were some errors in the court's allocution and the written waiver in the 2014 one, it did state that defendant still retained certain rights, and he did have an opportunity to discuss the waiver with his attorney.
Counsel, what's your position if one is invalid and one's valid? If the subsequent one is valid and the prior one is invalid?
In this case, I think they should be viewed together. And 2017 is the most recent one. And during the 2017 one, defendant was told by the court that he retained rights to appeal certain rights, which, as I noted, was given to him in the written waiver in the 2014. And he had opportunity to consult with his attorney in both instances. So if there were any confusion lingering from the original waiver, he had the opportunity to discuss it with his attorney in 2017 and raise it before the court. And he stated on the record that he had discussed the waiver with his attorney, and he totally understood it, and he did not have any questions from the court. So when everything is viewed in together, the waiver should be deemed to be valid, and his mandatory surcharge argument is precluded from appeal. If there are no other questions, people request an affirmance.
Thank you.
Quickly, I just want to address that the issue in this case is not whether or not the imposition of fees and surcharges is appropriate. The legislature completely abolished any mechanism under which a youthful offender could be charged fees and surcharges. The question here is whether or not the law is retroactive, and it is. It's an ameliorative law. It was passed to help indigent families and indigent defendants, and there's no indication that the legislature did not want this to go into effect immediately. There was a sense of urgency there.
You agree that, however, if there's a valid waiver of right to appeal, that's foreclosed?
I actually wouldn't agree with that, Your Honor. First, I don't agree that there was a valid waiver appeal in this specific case. And respectfully to this court who has decided this before, I don't believe that somebody could validly waive a right that they don't know exists at the time, and in fact does not exist at the time. An appeal waiver is essentially a contract. You can agree to parts of things and not agree to other parts, and this is not a part of the contract that he agreed to. Thank you.
Very much. Arias versus 139 East 56th.
Please, the court. Alex Walwick for the plaintiff appellant. Your Honors, neither the Supreme Court nor defendant has distinguished the three cases that we submit are governing in this case, Seagull, Lopez, and Kyle, all of which say that a harness that fails to prevent injury in a gravity-related fall is inadequate, and that therefore the plaintiff is entitled to summary judgment on Section 240. I have nothing more to say except that these cases are on point here, and the plaintiff here had a retractable harness. It did not prevent him from sustaining injury when he fell. He hit his head on a beam on the way down to about 10 or 12 feet. He suffered injuries as a result of the sudden stopping of the lanyard. Whether he hit the ground or not, before he fell, he suffered those injuries, whiplash kind of injuries. Therefore, the harness did not prevent him from sustaining gravity-related injuries, and I think there should be a reversal, and plaintiff granted partial summary judgment on his 240 action. Thank you.
Thank you.
Good afternoon. Patrick Lawless for the defendants and respondents. The court below properly denied summary judgment as there's numerous issues of fact as to how this accident happened, and the plaintiff has not come forward with any evidence that the harness and lanyard did not.
So what difference does it make which version of the accident is correct? Whether he hit his head on the floor or he didn't touch the floor, he did touch the floor. Why would that change whether or not there's ultimately liability under 240?
According to the plaintiff's own sworn statement, the harness and lanyard had nothing to do with his injury. He said that he hit his head on a...
Didn't he say that it bounced back, causing him injuries and causing him to hit his head on the beam? So if you accept plaintiff's version as true, why would there not be liability under 240 under cases such as Kyle?
Because there's no evidence that the harness and the lanyard malfunctioned. In Seagull, the case that's cited by the plaintiff, there was evidence that the lanyard was set up too low, which allowed the plaintiff to hit the deck below. In this case, he said that he was hit by a beam that he had just recently cut, but he hit his head on it, but the lanyard didn't cause any of his injuries. So according to his own sworn statement...
Although isn't really the test not whether the lanyard caused his injury, but whether the landlord was sufficient to prevent his injury, which clearly here it wasn't, right? He was injured. We all agree. He was injured.
He was injured, but...
Here at his neck, he hit his head. So, and under the statute, the question is, did what you give him, whatever safety devices you gave him, was it sufficient to prevent him from having an injury from falling, right? Falling is for sure. We all agree this is gravity related. And so then the question is, did what you gave him, was it sufficient to prevent his injury? He was injured, so clearly it wasn't.
But if you look at his statement, he's saying his only injury, in his sworn statement, he said his only injury was hitting his head, but that wasn't caused by any deficiency of the lanyard and the harness. The lanyard and the harness...
Right, exactly. So maybe if you had given him a net or something else, he wouldn't have fallen and wouldn't have had the opportunity to hit his head. That's the whole point. was that what you gave him, not whether it malfunctioned, it's was it good enough to stop him from being injured? And it wasn't.
Well, it did prevent him from falling and striking the ground.
Fair enough, he didn't die, but that's not the test.
But he could have,
That's not the test. It's never been the test.
but all he's saying is that he struck his head, and that couldn't have been prevented by anything else. He fell because.
How do you know that if you hadn't given him different safety apparatus, like a net around where he was working, or some other safety apparatus, that would have not?
I think that's entirely speculative, and I think that the lanyard and the harness performed its function, and I think it was an adequate safety device, and I think at the very least that there's issues of fact which required the denial of summary judgment. Thank you.
Thank you very much.
Very quickly, Your Honor, as has been pointed out, the device does not have to malfunction. The test is whether it was adequate to prevent gravity-related injury. Again, this lanyard did not do that. The plaintiff said that he hurt his head on the way down, but he also said, as I said, that he suffered whiplash injuries when he was deposed. And this was attributed by his doctor to the fact of the sudden abrupt stopping by the lanyard. That's all. Thank you.
Thank you very much. The next case is Nunez versus Morton. Go ahead. Go ahead.
May it please the court, my name is Patsy Morton, pro se appellant in this matter. Good afternoon and Happy New Year, Your Honors. I stand before you today seeking justice in this matter that has eluded us for the last 5 years. It is my prayer that this court will review the facts and the law of this case and the documents where the lower court overlooked their obvious deficiencies, such as missing papers and defective paperwork. I've entitled this case, The Case of the Missing Papers. As noted in the brief, there are missing papers connected with this particular order to show cause, where we are seeking to vacate the order to show cause. There is no note, there is no signature, there is no mortgage, there is no proof of default, there are no business records, there is no affidavit from anyone with personal knowledge of the matter. There is no proper appearance for the new res attorney. There is no proper consent to change attorney. There was no service of the judgments made by the court in December of 2021. There is no notice of motion by the newly named plaintiff, new res, and there is no creditor that was named in the matter. So we are seeking that the court vacate the judgment. I have been a defendant in the matter since 2017. I signed on to the NICEF. I was entitled to service of all the papers, and I did not receive the documents as required. So the court should have vacated the judgment.
Thank you.
May it please the court. Good afternoon, Your Honors. I just want to briefly respond. Ms. Morton challenges the propriety of the judgment of foreclosure and sale, but as the record supports, she failed to provide a copy of same on appeal, nor does she provide her opposition. So the challenges to the judgment motion are matters that dehor the record. Really, this is, despite the conspiracy theories that were presented, this was a case where post-judgment, the loan was sold and assigned, and there's an assignment of mortgage in the record reflecting same. And with respect to the fact that the judge amended his own judgment. The record also supports that, one, he reduced the amount that was owed to the respondent. That was his amendment that he made. And that's reflected in his initial on the record at page 64, where he signs that he's amended the judgment by reducing the amount owed to the respondent. He had inherent authority to do this, and there was no prejudice to the appellant. And if there are no further questions, I'll rest on my brief.
Thank you very much.
Thank you.
I submit that appellants were extremely prejudiced by the actions of the court. Also, as noted in the brief, the counsel is not properly before the court because they did not comply with the CPLR 321. And I pretty much went through that in the brief, and they were not before the court properly. The plaintiff, whose name is Nurez, is not represented by counsel, and they are an LLC, and they should have been represented by counsel. The original plaintiff was PHH Mortgage, and they are still the attorney of record. Thank you.
Thank you very much. The next case is Wilmington Trust versus Fife.
Good afternoon, Your Honors. My name is Gail Blvd. I represent the defendant appellant Christine Fife. In this matter, the motion to renew was improperly granted because it was untimely. A motion to renew can only be made before the time to appeal the order has expired. In this case, the time to appeal the order that granted dismissal based on the statute of limitations had expired.
Counsel, it's undisputed this argument wasn't raised below. Why should we consider it now at this point?
Well, because this is a question of law as to whether the motion to renew was untimely, and it appears on the face of the record, and it could not have been avoided had it been raised at the proper junction. The records, there is the notice of appeal in the record. The court can take judicial notice of its own records, which this court does often, and you can tell that the respondent plaintiff never perfected the appeal of the court's dismissal. So even though it wasn't raised in the court below, it is something that this court, it's on the face of the record, and it is a question of law.
And what's your issue about the COVID state? Because I know you talked about the timing from the notice of appeal. What impact does that have on this case?
Well, it has no impact on this case because this court lifted the stay and said that all appeals calendared for the November term were not extended. So there was no extension of time. The plaintiff had to perfect the appeal by the November term, and it did not. COVID did not affect this at all, and that's in the reply brief. The other thing that I think is important to note here is that on the motion for summary judgment based on the statute of limitations, the plaintiff only defended based on the fact that it stated that the prior plaintiff had no standing. It never once said that the loan had been deaccelerated. That was a defense that they never raised. Now, I know that what counsel will say and has argued is that the discontinuance, there was a flux in the law, and at the time, the law was that a discontinuance in the first department was not a deacceleration of the loan, so they didn't have to bring that forth. But I think what is important here is that they should have argued that the loan was deaccelerated, and they, by any means, and they never argued that. Lastly, I want to bring to the court's attention, and I gave the clerk a copy of AB 7737, which was just signed by the governor Saturday, the Foreclosure Abuse Prevention Act. And essentially, the legislature agreed with this first department's holdings in the cases that went up on appeal in Angle, and specifically holds that a discontinuance no longer acts as a deacceleration of the loan, and that is effective immediately. So it adds 3217 of the CPLR-E, and it specifically states that a voluntary discontinuance shall not revive, reset, cancel, toll the statute of limitations. So in essence, this new legislation has completely overturned Engel in that aspect. The other aspect that it overturned Engel and how it relates to this case is, it also says that a subsequent plaintiff in a second action cannot argue that the plaintiff in the first action had no standing unless the court in the first action made such a finding. In this case, there was no finding in the first action that the plaintiff had no standing, and this plaintiff is barred from arguing the same in this second action.
Can you give us the citation again to the new statute?
It amends CPLR 213-4, and the new section will be 213-4A. And the first one about discontinuance will be CPLR 3217E. It's a new section that's added. And
But we wouldn't even get to the issue of whether or not that statute applied in this case if we agree with your initial argument.
Exactly.
That it's untimely.
Yes, yes. And, you know.
And you didn't brief this new law in your.
No, I did not.
Okay.
I did not. I would be happy to, but it was clearly time barred. I mean, if a notice of appeal, a notice of entry had been sent to plaintiff, if they hadn't filed a notice of appeal, then the time to appeal that decision would have expired in 30 days. But since they filed the notice of appeal, their time to appeal expired when they failed to perfect within November term. Thank you, Your Honors.
Good afternoon, and may it please the court. Your Honors, my name is Liz Phillip, and I represent the respondent Wilmington Trust.
So why isn't the renewal untimely?
Your Honor,
Even giving the benefit of any COVID stay or other stays, why isn't it undisputed that this was not brought within the time to appeal?
well, Your Honor, I believe the question is that question clear on the record before the court? And the record before the court indicates that there was actually not clarity on that question. The only timing issues that were presented to the trial court were presented by appellant, indicating that nothing was proceeding in the courts due to COVID.
Well, don't we have all the relevant dates either in the record or in our own records, since we know as a First Department when the notice of appeal was filed and that it was not perfected within 6 months, which means the time expired as of that 6 months, and even if you factor in any COVID stays, you still didn't bring the renewal motion until after all that time expired. So why can't we ascertain on the record, based on undisputed facts, that it's untimely?
Well, Your Honor, that also does not provide for any possibility of any extensions requested by the appellant, by respondent of that notice of appeal or anything of that nature.
But we know that there was no appeal ever filed. There's no dispute about that. We know from our own record. So I'm not sure what the extension is you're referring to, because we would know about that.
That's right.
We'd see that in our own files.
Your Honor, it is respondent's position that the record isn't clear on the question enough for it to be raised for the first time on appeal.
But what are you saying isn't clear? All of our records say what they say. What is it specifically that you think is unclear?
Whether or not there were any other COVID-related matters that would have prevented.
Assuming that we take them all into account, right? All the executive orders and everything else, this would still be untimely.
Respondent is not sure about. If the court is clear on that question, then the court is clear on that question. But
What do you mean? What is it? What are you unclear? That's what I'm trying to figure out. What is it that you think is unclear? I'm saying we'll give you every single benefit of the doubt. We'll give you the First Department COVID. We'll give you the executive orders. It's still untimely, even with all that. So what's unclear?
If in fact there is no carve-out for it, then the court may determine that it was untimely, but it is being raised for the first time on appeal.
Okay.
And just as a side, I know the court isn't entertaining the new legislation, but respondent's position is actually it does not overturn Engel, and respondent can address that if the court is interested, but I don't believe the court wanted to hear about that matter right now.
If we have any interest in addressing that issue, we'll request additional briefing on it.
Thank you, Your Honor. We'll rest on our briefs. Thank you.
The only issue I didn't bring up with regard to Engel is that Engel clearly states that it is the actual withdrawal of the complaint that constitutes the overt act of deacceleration. In this case, because there was no stipulation of discontinuance, the overt act was the court order. That is what would have, court order discontinuing the action, that's what would have deaccelerated the loan. And there was no evidence that there was an order. There's a NICEF piece of paper that says that the case was dismissed, but nothing about the order. And it is just not true that it is irrelevant to whether or not the plaintiff knew, the defendant knew about the deacceleration. What is important is that the plaintiff made some attempt to mail or notify the defendant of the purported overt act of deacceleration, i.e. the order discontinuing the action. Just like when you send a deacceleration letter, the plaintiff must prove that it actually sent the letter. Not that the defendant received it, but that they sent it. And there's no evidence that the plaintiff ever sent the notice, the order of discontinuance. I thank you.
Thank you. People versus Johnson.
Good afternoon. For appellant, Nicholas Schumann-Ortega. At every step of the police encounter in this case, the officers acted well beyond what could be deemed legal or reasonable. They stopped a moving car where appellant was a passenger without probable cause of a traffic infraction and without even the intention of issuing a traffic summons. And then after the illegal stop, they proceeded to search the car's compartment without even reasonable suspicion of a crime.
Counsel, let me ask you about that stop, because the police officer did testify that the car was doing something illegal and that it was stopped. It was not just picking up, but it was stopped and idle in front of the hydrant, which is a traffic violation. What evidence was there that contradicted the police officer's testimony and would create a basis for disturbing the credibility determination in favor of the police?
Well, as to the hydrant issue, under VTL 1202, subsection B, subsection 2, standing idly by a hydrant is actually not a traffic infraction. The statute says that it is permissible to stand by a hydrant, and I'm quoting directly from the statute, when such vehicle is attended by a licensed operator who can immediately move the car, and that's precisely what we have here.
But how did the officers know that the person sitting in the driver's seat was a licensed operator?
That's a good question. So the officers were, under these circumstances, permitted to go up to the car and conduct a level 1 request for information. They could ask.
But didn't they pull away? They pulled away when according to what I remember of reading the facts here, the police van pulled up in back of the car. It wasn't just a fire hydrant, it was also a bus stop, which is a no standing zone, right?
Well, that was the testimony, although that was contradicted by photos.
When you're saying the level 1, they couldn't do a level 1 because based on, from what and please correct me if I'm wrong, the car pulled away.
Yes, the car did exactly what it was supposed to do, and basically what
How is it going to do a level 1 if they pull away?
I'm sorry, Judge?
How would they do a level 1 search or level 1 inquiry if the car pulls away after they pull up in back of them?
They couldn't at that point, and under this court's decision in People v. Thomas, a level 1 inquiry is all that's allowed under these circumstances. And the reason that is because all the police officers could do is ask for their license and tell them to move if they are licensed. The car moved.
Counsel, I think the VTL talks about in terms of parking. And I think the testimony of the police officer was that it was parked. So let's go back to that language. What's the contradictory evidence that it was not parked?
It was standing. The hearing evidence, as to this point, I believe was uncontested. The car was standing with the engine running and a driver in the driver's seat. That was uncontested at the hearing. The issue was whether after that car moved, they could pull it over, and then, of course, after pulling over the car, whether they could search the car's interior. So as to the search, the court below relied on People v. Torres, which does authorize a limited protective search of a car where there are two prongs met. A, that there's reasonable suspicion that a crime has been committed, and B, that there's a reasonable likelihood that a weapon inside the car poses a risk to the officer's safety, and neither of those requirements were met here. There was certainly no reasonable suspicion of a crime. There wasn't even a finding of reasonable suspicion by the court below, nor was there sufficient cause to believe that the search was necessary to protect the officer's safety.
What about the testimony that the defendant was opening the passenger door and was hunched over with his hands on the floorboard? Why isn't that enough to create an issue about the reasonable safety?
Well, I don't believe that those movements on their own create a reasonable likelihood that a weapon is in the car, especially given the innocuous traffic infraction or the alleged traffic infraction.
The counsel wasn't, in fact, a weapon, a loaded weapon on the floorboard where the guy was bending down to reach into?
There was, Judge, but that was ultimately...
So you're saying I come up to the car and somebody reaches, instead of handing me their license, they reach down to the floorboard, and that doesn't raise any reasonable suspicion?
No, I don't believe that it does. In fact, under this court's decision in People v. Newman, furtive movements on their own after a traffic infraction are insufficient to justify a limited protective search of a car.
Thank you. You have time on rebuttal to further respond.
Good afternoon, Your Honors. May it please the Court, ADA Nelson on behalf of the respondent. As this court takes notice, the officers did actually have reasonable suspicion, and it turned into probable cause. It started at level 2. Officers had the right to make a proper inquiry when the car was illegally stopped in front of a hydrant as well as in a bus lane, as this court noted. Yes.
Once the officers had moved the defendant and the driver to the back of the car, what evidence is there that the officers were still in any danger sufficient to justify the officer's search of the opening of the plastic bag on the floor of the car?
The evidence is when the two defendants were in the back of the car, they were not handcuffed. They still were in close proximity to where the movement took place. So when Officer Corcoran initially walked up to the car and seen the defendant making the movement on the floorboard, he also realized that there could be a potential weapon in that same proximity. When the defendants were in the back of the vehicle, they still had leverage to go and get a weapon if a weapon was there, in which it was there, as this court noted.
Counsel, how do you respond to your adversary's position that once the vehicle took off, that the officers then didn't have a basis to stop it?
The officers did have a basis to stop because, as Dubois says, level 2, we have a basis to make an inquiry when we feel that there is a crime afoot. And adversary misspoke when he said there was no crime. You are obstructing a public bus lane by the city. That is a crime. And when the officers pulled behind, they couldn't make the inquiry because the car pulled off. So then they initiated the sirens and the car stopped. And there was a pairing of events that I want to highlight to this court. One, the defendant immediately opened the passenger side door, and Officer Corcoran testified on record saying that never happened in his routine traffic stops. And he thought maybe the defendant may attempt to flee. 2, we have the hunching and the fumbling on the car floor. And then 3, we have the car pulling off initially. So with all those pairing and the factors that come into play, that was a very necessary limited search that Officer Corcoran did. He just searched the area where the movement took place. He didn't search anywhere else, any compartments, trunks. He just searched the area where the movement took place.
But wasn't the car pulling away a termination of the alleged criminal act?
No, because if an officer has the rights by law to make an inquiry, how can he make an inquiry when the defendants are rolling away? you can't make an inquiry, right? If a crime is afoot,
But there's no longer a crime afoot because the crime was that they were sitting there. So if they're no longer sitting there, what crime was afoot?
well, the sirens is indication by law. When an officer or law enforcement patrol van turns on their siren, any motorist knows, licensed motorist, that you have to now abide by that siren and stop. So when they stopped, that's when everything else took play.
Thank you.
Thank you.
Briefly, once the car pulled away from the parking spot, any traffic infraction that possibly could have existed had ceased to exist at that point.
You're saying, by that argument, you're saying that every person that commits a traffic infraction, once they decide to move away, the law enforcement no longer has the right to issue a ticket? Or that's it? Oh, you get to leave and that's the end of it, right? I'm not so sure that that's something we want to condone, right?
But not every traffic infraction, but the traffic infractions at issue here, which do allow temporary standing by hydrants or bus stops.
I don't disagree with you, but that's at the discretion of the law enforcement agent, using their discretion, saying, okay, you're in a no stopping zone for the bus, don't do it again. At this point, it didn't happen. I mean, they just decided to leave, and according to your argument, that's okay. Once the infraction was committed and they decide to leave, there's no longer any punishment that's warranted.
Well, my argument is that there was no traffic infraction because standing temporarily by either a hydrant or a bus stop, although there was no bus stop at this corner,
okay, those bus
it is
lane,
not in and of itself.
those bus lane cameras would beg to differ on that one. But anyway, okay.
Well, there was no bus stop at this corner. It needs to be an officially designated bus stop. But standing temporarily by a hydrant is not in and of itself a traffic infraction. Thank you.
The next case is Chester versus Cleo Realty.
May it please the Court, Jonathan Sperling for Defendant Appellant. This is an appeal in a pre-Roberts J51 deregulation case. Your Honors, following commencement of the action, defendant filed corrected registrations with GHCR.
Wait, you're referring to this as a pre-Roberts case, but your client continued to not register the units as rent stabilized even after Roberts was decided and after Gersten was decided. So why is it a pre-Roberts case?
Your Honor, that's the terminology that the Court of Appeals used in Regina. It's the terminology that this court used in Montera, right, to differentiate between cases in which the deregulation took place before Roberts and Gersten were decided versus cases in which the deregulation took place after.
But then those were decided and these units were still not, your client took no steps to register these units, correct?
That's correct, Your Honor. So let's turn to that. Okay. Those cases were decided. After this case was brought, and I'll walk through the facts for Your Honor in just a moment, but I want to highlight that after this case was brought, defendant filed corrected registrations with DHCR. Those corrected registrations showed that with respect to 5 of the 6 plaintiffs, because for plaintiff shower there was no overcharge at all, we'll turn to that momentarily. For the remaining 5 plaintiffs, the overcharges in the aggregate were just under $8,400. Here.
So haven't we made clear, though, since the initial cases, that once a landlord knows about Gersten, that it can't go ahead and wait till a lawsuit is commenced to then bring the apartments into rent stabilization. It has to take affirmative action, or else it's going to be found guilty of, go to the default formula.
Right, so let's go through the facts, Your Honor, if I could identify one thing before I respond directly to Your Honor's question, which is the overcharges in the aggregate here were $8,400. Supreme Court, I see Your Honor shaking your head, but those are the facts. Supreme Court granted summary judgment on fraud, right? applied the default formula, applied a rent freeze, and entered judgment for over $4 million. Now, here's what the facts look like if they're viewed in the light.
So you're saying that the lower court's calculation was wrong and your calculation of $8,000 overcharge is correct?
Your Honor, I don't think that there is any evidence in the record that is contrary to the fact that if the rents are recalculated according to the reconstruction method, the total overcharges during the 4-year look-back period.
But the question is whether the reconstruction method is correct or the default method.
Correct, Your Honor. So that turns on the finding of fraud. I see that the light is on, but if I could walk through briefly.
You have another minute.
Thank you, Your Honor. Supreme Court, in 8 sentences, summarized the facts here in the light most favorable to the plaintiff, not to defendant. Here's what the facts look like if they're viewed in the light most favorable to the defendant. Regina Metro says there can be no fraudulent scheme to deregulate in pre-Roberts cases. There's no inference of fraud, no inference of knowledge, Your Honor, because you asked, well, what about knowledge of Gersten? There's no inference of knowledge from the Guds v. Gemrock litigation that plaintiffs point to, because that was decided before Gersten. And in fact, the court there said the retroactivity of Roberts is an open question.
But Gersten was decided in 2011.
Your Honor, if your point is that the mere passage of time is sufficient, then there are numerous cases decided by this court that say otherwise. For example,
No, but Gersten says that Roberts is retroactive.
Yes, Your Honor.
Right? So in 2012, you should have known that it was binding First Department law that Roberts was retroactive. And that would have triggered your obligation to re-register the apartments. And you didn't do that until you were sued in 2017, correct?
Correct, Your Honor, but the logical implication of what Your Honor is saying is that after 2011 or 2012, there always should be a summary judgment determination of fraud because Gersten had been decided. There are numerous cases by this court that hold the contrary. I'll mention just one because I see that the light is gone, but I want to answer Your Honor's question. The Austin case, cited in our briefs, decided by this court last year, Justice Owing on the panel. In that case, the owner deregulated for the first time in 2014, 3 years after Gersten, and unlike in this case, was still receiving J51 benefits. And this court found insufficient evidence to grant summary judgment on fraud, reversed Supreme Court's finding of fraud on summary judgment. So there's lots to say about the evidence here. I'm not suggesting that there is no circumstance in which, after hearing all the evidence at trial, a finding of fraud might be made. But Supreme Court had no basis entering summary judgment here, and its determinations were filled with errors and absolutely viewed the evidence, in the light least favorable to the defendant.
Are there any more questions? Thank you.
Good afternoon, Your Honors. Timothy Collins.
So what do you say to that? That the landlord says, give me a trial because I can prove that it wasn't fraud here.
Fraud is eminently clear here. In 2011, the appellant was involved, and the landlord in this case was involved in another lawsuit in 2000.
Okay, but those are trial court decisions that can easily be, we overturn decisions on appeal often, right? It's not unsurprising. I would not say that a trial court decision is binding law in this department.
Absolutely,
right?
Absolutely correct, Your Honor.
So then,
what I'm
those
saying
two
is,
trial decisions. What is it that you're saying shows as a matter of law that there was fraud here?
because those decisions, as the court below found, provided sufficient notice of the obligation under Roberts. The first decision
Again,
said
I'm
that
saying to you that those were trial-level decisions. Taking those two decisions out of the equation, what else do you have to prove fraud as a matter of law?
Okay, well, I wouldn't take them out of the equation, but taking them out of the equation for argument's sake.
Just give me my due here,
yeah,
okay?
Yes, of course. The fact is that Roberts was decided in 2009. Our case was brought in 2017. In February of 2017, when we filed our case, we basically spoon-fed them the details of their legal obligations in our complaint. They continued to issue 5 leases, lease renewal offers at market rate rents with bold statements at the top, bold titles saying this is not a rent-stabilized lease, including riders that the tenants had to sign, admitting that these are not rent-stabilized leases. In the 6th case, they had already issued the offer, but not consummated the lease. The lease was consummated and put into effect after this claim was brought. And while this activity occurred post-complaint, it is clearly evidence of intent to avoid their obligations under the law. This is not a landlord who saw its legal obligations and came forward and said, well, look, we made a mistake, let's talk about it, let's fix it. This is a landlord that was dragged kicking and screaming into Supreme Court, dragged this over to DHCR, we had to get it back to Supreme Court, and the evidence, there are 30 leases that were issued after the base date in this proceeding, all of which occurred at least 2 years after they had been involved in that prior litigation, which the court found sufficient to prove scienter. I'm not sure what else I would add here, Your Honor, other than, Regina's clearly doesn't stand for the proposition that landlords have a right to continue deregulated tenancies in perpetuity.
Have we, the first department, granted summary judgment before in this situation as opposed to finding issues of fact based on the landlord's failure to adhere to Regina and Gersten?
Well, if there were issues of fact, but I think the issuance, again...
I'm just asking, are you aware, based on your research, as to whether this court has actually granted summary judgment to a tenant in a situation such as this one, or would this be a first?
A summary judgment has been granted in, I believe, in connection with some of the decisions granting class status.
No, when we're talking about fraud, I mean fraud.
Yeah, the Ford default formula where it's a post-Roberts case, like a Montero situation. I know Montero, we didn't grant summary judgment, we just found no issues of fact as to whether the default formula. But are you aware of any cases where we actually granted summary judgment to the tenant, finding as a matter of law there was fraud based on the landlord's failure to adhere to re-registering after J51 tax benefits?
I believe there was one prior case that came up from Justice Nervo that was sent back, and fraud was, Justice Nervo needed to establish that fraud had in fact occurred, and that was done after a remand.
Mr. Collins, counsel raised the question of a decision of ours called Austin. Can you distinguish that from your case?
I'm sorry, which decision?
Austin.
Oh, the Austin case. My understanding is that Austin found that the plaintiffs were correct, that because the defendant's predecessor provided them with market rate leases claiming the apartment was deregulated in 2013, well after the Court of Appeals decided Roberts, defendant cannot claim reliance on DHCR guidelines when it deregulated the apartment. So Austin is distinguishable in terms of the mechanism that was used in this case, as well as in Austin, to bridge the gap, as I believe they describe it. So Austin is clearly distinguishable.
Thank you. Any further questions from the bench? Thank you.
Your Honor, two things. First of all, with respect to the Austin case, which is 202 83rd 429, again, this court reversed the grant of summary judgment to plaintiffs, and not only was...
On a finding of fraud?
Yes, Your Honor. And the re-registration in that case happened in 2018, later than in this case. So the deregulation took place later than in this case, and the re-registration, the correct registrations, took place later than in this case, and this court reversed the grant of summary judgment.
Well, let me just ask you, what evidence have you put up to show that, the plaintiff has said, here's my evidence of fraud, boot, 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 and boot. What do you have to dispute that? Why is there a disputed issue of fact?
Your Honor, the plaintiff has not put forward evidence.
Assuming that I think that the plaintiff put forth a prima facie of fraud, what evidence are you putting up in opposition?
I would point to at least two things, Your Honor. First of all, the defendant's compliance with Policy Statement 89-2, which the courts have repeatedly recognized as evidence of good faith, which needs to be taken into account. And I would point to the fact that for substantial portions of the look-back period for each and every plaintiff, there was no overcharge of any kind. That's inconsistent with a fraudulent scheme to overcharge. Okay? Now, if I may, I wanted
Well,
to...
isn't overcharge a separate thing from whether rent-stabilized leases were offered? When you say no overcharge, were they being offered, they weren't being offered rent-stabilized leases?
That's correct, Your
So
Honor.
isn't that a completely different question than what rent they were being charged?
I don't think so, Your Honor, because the question is whether there's a fraudulent scheme that caused them harm.
Well, no, the question is whether they were fraudulently trying to take them out of rent stabilization when they should have been in rent stabilization. That's the question. So if you weren't offering rent-stabilized leases, isn't that clear evidence of a fraudulent scheme?
Your Honor, there's only two possibilities. Either the deregulation was fraudulent, that happened before Roberts and before this court held in Gerson that was retroactive, or alternatively, that the overcharge later. There can't be a fraudulent scheme to deregulate in years after the deregulation already happened.
Thank you.
If the court could indulge me for 30 more seconds.
No, unless anyone has any more questions. Your time's up. Thank you.
Thank you, Your Honor.
Rwanda versus New York City Housing Authority?
Good afternoon, Your Honors. Miriam Skolnick from Hertzfeld and Rubin for the New York City Housing Authority. I think as the Court of Appeals made clear in Rivera, and as this court has recognized in several cases, there is no common law duty to insulate pipes. The duty can only be imposed by the legislature. Here, the legislature has not imposed a duty to insulate the pipes in this particular apartment because it's a pre-60 building and the 68 code doesn't apply. The question that arises here is, was there a defect in the heating system that they failed to repair? Now, the defect in the heating system here has not been identified. Our expert came in, looked at all the records, said this complied with industry standards. That was enough to shift the burden of proof. Their expert came in and said, well, I'm an expert, and I'm telling you it could have been better. He doesn't say it violated any rule. He doesn't say it violated any industry standard. And he doesn't even say in what way it was defective, because ultimately, his opinion, had the pressure here been lowered to the 3 PSI that he advocated, the pipes would still have been too hot, according to his definition and according to plaintiff's definition, because at best, it would have lowered the temperature from the 235 of the steam in the boiler, which is the temperature we're talking about. The steam in the boiler would have been 225 degrees. And it would have exceeded the 162 that their experts say would have caused instant destruction of skin, and in no way would it have prevented plaintiff's injuries. It still would have been, quote unquote, too hot, and there's nothing here that he's advocating that would have avoided these injuries. There's no repair, there's no broken pipe, there's no excessive water coming through. It's basically a heating system that was functioning the way it was supposed to function. And the only defect that's been identified is the failure to insulate the pipes, but that doesn't exist here because the legislature has said you don't have to insulate the pipes in a pre-60 building. They do provide, unless it exceeds a temperature of 250 degrees, which here there is no evidence of that. Court have any questions?
Thank you.
Good afternoon, Your Honors. The plaintiffs had never made the claim that there was a defect in the heating system or that it was malfunctioning. The claim has always been that the Housing Authority did not maintain its heating system in a reasonably safe condition.
But if it was acting consistent with the 1938 building code, then I'm having trouble understanding what your theory is of liability, especially in view of our decision in PR versus New York City Housing Authority and the Court of Appeals decision in Rivera versus Nelson Realty. It seems to me that once they've complied with the regulation, they've done everything they have to do.
Right. Well, Rivera made a specific distinction between radiators and pipes. The court in Rivera explicitly said it makes sense that their decision is not talking about pipes coming from a radiator. It only relates to radiators. So that's the distinguishing feature in Rivera. I think Judge Kotler, Your Honor, framed the issue here very well in her decision that the Housing Authority is missing the point. So we know that the Housing Authority has a duty to maintain its premises in a reasonably safe condition. It does not have a duty to provide insulation or covers for heating pipes based on clearly established precedent. We know that.
So I'm going to ask the same question. If it doesn't have an obligation to cover the pipes, what is the basis of liability?
However, if the heating pipes in the subject apartment were in an unreasonably safe condition, then NYCHA breached its duty to maintain the premises in a reasonably safe condition so long as it had notice of the dangerous condition.
You're citing to Judge Kotler's decision.
I am, and I also...
What's the authority, since there is a well-established body of authority that there is no duty to cover the pipes, and you've conceded there's no defect in the heating system, what then is the basis for liability? Because those would be the two reasons why liability would be imposed.
To answer your question, the authority, you can look at Bruno, Your Honor, and the reason why the court found for the Housing Authority in Bruno was in the absence of competent evidence showing that the heating pipes were permitted to reach an unreasonably high temperature. There are no tribal issues of fact as to the
Again, all
defendant's
your
negligence.
experts said was, I think, 6 versus 8, and that would not have made a discernible difference in the temperature of the pipes.
But in all of these first apartment cases, there's something that's missing, whether it's the plaintiff didn't have an expert to rebut the defendant's expert, you're talking about radiators. That's not the case here. And the way that the courts...
But I guess the question is still, your expert doesn't rebut the showing that had the Housing Authority done what your expert said, it would not have materially reduced the heat from the pipes. So I'm not really sure, again, so how could that have been negligent?
And it was negligent because they were at such an unreasonably high temperature for the temperature outside at the time. It should not have been operating where the pipes are 235 degrees when it's a mild November day out. So in Isaac and White and PR, the temperature of those pipes were 165, 180. So it's certainly possible that they could operate it where those pipes are not as hot. As the boiler technician Brown said, that the pressure and the steam temperature could be as low as 105 degrees. So the distinguishing factor here is that it's 45 degrees out in November, and they're operating it as if it's the harshest winter night. And as the court said in Bruno, this court said, in the absence of competent evidence showing that the heating pipes were permitted to reach an unreasonably high temperature. There wasn't any competent evidence in Bruno. We have the evidence here.
Thank you very much. Thank you.
Thank you.
If I may real quickly explain that the difference that the Rivera court noted between radiators and heating pipes is of no application here because the difference...
But how do you respond to this notion that the pipes were unreasonably hot? That the plaintiff's expert said that they were, even though they are below what the regulations would...
Well, unreasonably hot for what reason? According to the plaintiffs, he said we should have lowered the pressure, but they still would have been unreasonably hot. And the distinction that counsel is making between the cases where the pipes were 180 degrees According to plaintiff's own expert, 180 degrees would cause the same injury that happened here, particularly given the amount of time that we don't know how long he was against the pipe, but it was more than instant touching. So it's unreasonable once you have a severe burn. That makes it unreasonable if that's the standard that's going to apply. And unless there's something that we did wrong that caused it, which here, there's been nothing identified, and he admits that there's nothing that we did wrong. And otherwise, it's left up to the legislature. And the legislature here has spoken. And unless the court has any other questions.
Thank you very much.
Thank you.
Polanco versus 756 Joma.
Good afternoon, Your Honors. May it please the Court, Michael Zhu, Appellate Counsel, the Rimlin and Associates, attorneys of record for the plaintiff. The trial court here erred in granting the defendant's motion for summary judgment because the defendant failed to meet its prima facie burden. In a slip and fall case such as this court well knows, the defendant has a burden to come forward with admissible evidence establishing when the area was last inspected. In its motion, the defendant submitted the depositions of Mr. Estevez and Mr. Castillo, and neither witness testified as to when the area was last inspected. This failure of proof establishes that the defendant didn't meet its burden, and having failed to meet its burden, the court should never have granted the motion regardless of the sufficiency of plaintiff's opposition papers. The defendant pays lip service to this by saying in its respondent's brief that inspections were made. Well, the only testimony to that effect was from Mr. Castillo, who says that there are employees that go up and down the aisles and they look for things. And Mr. Estevez says the same thing. But they never testified on that day, the date of the occurrence, when that area was last inspected. And absent this evidence, the motion should have been denied as a matter of law. Unless the court has any, I mean, I can go into whether there were issues of fact.
Thank you very much.
Thank you.
The next case is Layton versus Seagull.
Good afternoon, Your Honors. May it please the Court. My name is Jared Behar. I represent the appellant, Scott Layton. The basic error that the lower court made in granting summary judgment to the defendants was it added a term that is not present in the relevant operating agreement to the operating agreement. And that clearly violates basic Delaware contractual law that governs the operating agreement at issue in this case. The Supreme Court of Delaware in Murphy versus WHC Ventures specifically said, you cannot add terms that do not exist to an operating agreement, particularly when the parties could have drafted such terms and conditions themselves. And that's exactly what the lower court impermissibly.
So is it your position that you were entitled to the promote fee even if you did nothing to get the zoning variance accomplished?
That's exactly right, Your Honor. In fact, the operating agreement specifically does not have a success requirement for the promote duties that my client had.
That would happen at any time, even after your duties ended in 2018?
That's exactly right, Your Honor, and there is a specific clause in the operating agreement that they negotiated, that Mr. Miller negotiated with my client, that could take away the promote. It's called a promote forfeiture event, and it appears in section 4.3C of the operating agreement. And so they clearly contemplated that there were circumstances pursuant to which my client could lose his promote. However, it fully vests. There is a vesting schedule. Defendant Miller admitted in his deposition that vesting is a very common feature of these types of operating agreements, and it simply doesn't make sense that there was a point in time where the promote could become fully vested, but then if the nature of the deal changed, it could be completely taken away.
So is your position that under the terms of the agreement, if there was not a specific promote forfeiture event as it's defined in the agreement, that's it. Your client gets the promote.
That's exactly right, Your Honor, because
And that it's conceded that there was no promote forfeiture event because even opposing counsel is agreeing that didn't occur.
That's exactly right, Your Honor. And because of that, because within the four corners of the agreement, there is no other way that the promote could be lost, the decision of the lower court, which essentially added a term to the operating agreement, completely should be reversed.
Because you're saying that, just so I understand, that there's no provision of the agreement that deals with whether or not your client gets the promote and whether or not it's forfeited, other than those terms that are in the promote forfeiture clause.
That's exactly right, Your Honor. So in section 4.3, which is the waterfall provision, it says, my client gets 15% of the second tier of the waterfall. Then later on, it says, here's how you could lose it. The deal changing in some unanticipated way is not one of those terms. And what the lower court did is it added that in as a term, just because they felt like it was a bad deal after the fact. But the Supreme Court of Delaware specifically says in numerous cases cited in our brief that you're allowed to enter into a bad deal. The law enforces both. You really have to just look at the four corners of the agreement. And here, the term that was impermissibly added in by the lower court exists nowhere.
And counsel, the way that this is written, the promote that your client would get, in terms of it being reduced, the reduction lessened as time progressed, correct, until it was fully vested.
Well, so Your Honor, what happens is because the first tier of the waterfall requires a 12% internal rate of return that compounds monthly, the longer that they withhold distributions, the more interest accrues and the less a promote there is for my client. In fact, with respect to the sale proceeds at this point in time, there is no promote anymore because you have 8 years of 12% interest that's compounded monthly. That gets to our second argument, Your Honor, as to why the covenant of good faith and fair dealing claim should be reinstated, because while they have discretion, that's not the point. The point is that they use that discretion pretextually and in bad faith to punish solely the appellant for refusing to give up his promote. The lower court said, well, you weren't entitled to the promote anyway, so therefore that couldn't be the pretext. But if you reinstate the promote, then it's very clear that we have, in contrast to the cases that the respondents cite, a highly particularized factual pattern.
You're saying because of the delay in giving the distributions from the sale, that has caused the promote to virtually disappear and no longer exist.
That's exactly right, Your Honor.
And there's a question of fact as to whether or not that was in good faith or bad faith, right? Because the defendants say we did it in good faith, we may do something else, and you're saying, no, you did it in bad faith, you're trying to get rid of my promote, and this is how. So that's, you're not saying you get judgment on that, you're saying that goes to trial.
Right, Your Honor. In contrast to the promote argument, where I think this court should search the record and grant us summary judgment dismissing the third cause of action, with respect to the covenant of good faith and fair dealing, we're saying, yes, there was a meeting, they made a threat, they carried it out, we memorialized it. They say, I don't remember it, but at the very least, you're right, that is an issue of fact. With respect to the other argument.
You'll have time for rebuttal.
Yes, thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. Greg Wiener for the respondents. May it please the court. So first, to just address the distributions point.
Well, counsel, let's talk about the prime forfeiture event and whether or not they're entitled to it. If we look to the language of the contract itself, you're conceding that there has not been a forfeiture event as defined in the agreement. Is that correct? Because you're saying that he shouldn't get it even though there hasn't been a forfeiture event.
Right.
Right?
We're
So
not
why
saying he loses
should we go
it.
beyond what the agreement says? And the only thing the agreement seems to say is that if there's not a forfeiture event, he's entitled to it.
Well, what we're saying is this is just a question of interpreting the contract. And in interpreting the contract under Delaware law, which is controlling, the purpose is to give effect to the intent of the parties. And we're dealing with a situation.
Okay, but let me just stop you right there. The intent of the parties is often and almost exclusively expressed through their writing, right? Not what they think in their mind, but they don't write down. So what section of the agreement expresses what you say the intent of the party is, which is if he didn't get the zoning resolution, he wasn't getting the promote? Where does in the agreement is that intent expressed?
The issue is, Your Honor, the parties
No,
are
I'm
dealing.
asking, yes, I know what the issue is. I'm just asking you, what language in the agreement are you pointing to that would express that intent?
We're pointing to the definition of the promote partner obligations, which indicate that his job was to get entitlements for the residential property, which everyone agrees was the purpose, and up through 2017.
But
And what
it also
happened is
went
the
on to say,
project took
excuse
a-
me, but it
Yes, sir.
also went on to say that he got the promote unless there was a forfeiture agreement. So what is there? I'm sorry?
Forfeiture.
Forfeiture event, sorry. So what is there in the agreement that allows you, your client, to deprive him of the promote in the absence of a forfeiture event?
Well, because, Your Honor, the purpose of interpreting the agreement, again, is to give effect to the
I
intent of the
understand what you
parties.
think is the purpose, but could you tell me anything in the agreement that
Yes,
specifically gives your client the right to not pay him the promote in the absence of a forfeiture event?
It's reflected in the terms of the agreement, which show that the promote was tied to specific time and efforts, and the project completely changed in a 180-degree, totally unanticipated way. No one disputes that, and Mr. Layton testified
Well,
if
Counsel,
the
where in
parties
the
knew...
agreement does it say that if the deal switches and a different deal comes into play, he loses his right to get to promote? Where is the language of the agreement, in the four corners of the agreement, that so provides?
No, it doesn't. I will acknowledge
Why
it
then
doesn't
should we ignore the plain language of the agreement, which does lay out the circumstances in which he forfeits the promote, to go with your analysis, which is not contained in the agreement?
Well, as Justice Leibovitz said, in interpreting the agreement, you avoid an absurd result and a result that makes no sense. And he found that to have Mr. Layton receive a 15% additional interest for no work, for no obligation.
Well, you know, that's actually covered by the promote forfeiture event. At the definition, it says, anytime before January 1st, 2018, the promote member ceases to perform his obligations under section 6.8 hereof, which is the residential zoning stuff, right? And does not resume performance of such obligations within 10 days after written notice from the managers. That's your default, that's your forfeiture event. So that when you're saying, you know what, we changed the plans here, we changed the transactions, you could have sent out a notice at that point saying, look, you know what, you're not going to be able to do this. We're not going to be able to complete the transaction as we initially said. So therefore, you know, we'll give you whatever notice you want to give, and that's the end of it. And you could argue at that point, I got to promote forfeiture event that happened. You'd be on stronger grounds to argue instead of arguing in front of us now saying, well, could have, should have, you know, it's there, it's there, it's there. But that really was the way to get out of this, right?
Understood. And so let me pivot, though, to the distributions.
I guess I hit the ball then. That's
yeah,
good.
it's correct, Justice Owing.
He's nodding his head,
the
too.
distributions argument, there is no disputed issue of fact that precludes summary judgment. The managers have the sole discretion to determine.
Yeah, you have the sole discretion. Yeah, you have the sole discretion, but you know what? There's a cost to that discretion too, which he's taking it. You know, he's taking it to the bank, as they say.
But Your Honor, just as you said, the parties could have anticipated.
No, but you have an obligation to exercise that discretion in good faith.
Oh, and there's no question the record shows that.
No, he's saying you didn't.
Well, he can say it all he wants.
And that creates an issue of fact.
No, Your Honor.
As long as his testimony under oath is, this is the reason why they did it, it may be yours is different, but we can't just say, plaintiff, you're a liar, defendant, you're telling the truth.
You don't have to say he's a liar. There is no case in which a party has discretion, a manager's discretion, to make a determination, and they put forth a good faith, rational, reasonable basis. Here, there's a $50 million project. They're holding $6 million.
But that project is for a different company. It's not even for
oh, no,
the company that he gets.
It's the wholly owned entity that owns the land. There's no...
But they're two different companies.
No, but all of the funding comes from Blvd Goshen, the entity that Mr. Layton is a party in and that he wants to force the distributions from.
Okay,
There's not a
thank you.
single,
Thank you very much.
thank you, Your Honor.
Your Honor, appellant, wait for bottle.
Okay, thank you.
That's good. Did hit the ball.
The next case is Sangar versus 985 Bruckner.
I have these.
May it please the court, Brian Kalman, London Fisher, for the defendant's appellants. And I'll try to be brief. The trial court on record site 8 said that the plaintiffs basically established that the injuries were caused by the incident. Even the plaintiffs concede that that should be a damages trial. We wanted to be clear that we can establish whether or not the alleged injuries, especially the back, was caused by this incident. And we think that there'll be evidence that there was not. And that was actually an issue in the court's recent decision in Pinzone against Royal Charter, where they said you could have...
Counsel, the plaintiff is only seeking judgment on liability, not on damages.
I understand that, and I think the problem was at the lower court, the trial court, on the last page of the decision, 3 of 3, this court finds that plaintiffs made a prima facie showing of a Labor Law 240 subsection 1 violation, as it was uncontradicted that plaintiff's injuries was caused by the defendant's failure to secure the scaffolds wooden. There's a big debate about whether or not the back injuries were actually caused by this. The plaintiff didn't seek treatment for the injuries for the back for at least a week later, which is similar to Vargas, which brings into that this...
I'm a little confused because there's no question that when you go to trial, you can make any argument as to liability that you want, that any specific injury was not caused by the violation. The only finding was that there was a 240 violation, so...
The trial court should have made that clearer, and our concern was basically it would be used against us on a collateral estoppel basis. The way the decision
You're seeking
was
clarity as to that it's only liability?
correct on that issue. Then moving on the credibility issues, Your Honor. Basically, under Vargas, first of all, premature. We didn't have an opportunity to depose any of the witnesses the plaintiff basically identified. Basically, if this plank that struck the plaintiff was horizontal, not a gravity-related issue, it wouldn't be a 240 subsection 1. Going down to the credibility issue, it's an unwitnessed accident, which I understand that the court
Hold on a
grants
second,
summary
hold on a second. Where is your affidavit from the supervisor, Carlos Brella, who has apparently told the plaintiff, don't say anything? Where's that affidavit?
That's not someone that we represent. That's a non-party.
Okay.
That's his employer. That's RSC. And, Your Honor, that makes the point very clear. If we could have had the opportunity to actually get the people, to get the affidavits, we could have opposed the summary judgment motion. Ultimately, he may have gotten it. We should have had the opportunity, because therefore, this is giving a license for the plaintiffs to make a quick summary judgment motion. You don't have the time
You
to
make
do
it sound like, you're looking to just raise a factual issue, right?
Correct. That's all.
So you could have just put in an affidavit saying, I can't get Carlos's affidavit because he refuses to give me one.
Understood, Your Honor. Going down
Counsel,
to...
going back to the question about whether this is about liability on damages and whether there's a lack of clarity, the trial, the motion judge's decision said plaintiff summary judgment, motion seeking judgment on liability is granted. So I don't understand why you're concerned that you won't be able to raise issues related to damages.
My concern was basically the first full paragraph on page 3 of 3, that the violation was uncontradicted that the plaintiff's injury was caused by defendant's failure to secure the scaffolding. My concern is I don't think that words are superfluous. I see it in there, and basically, I'm not saying the plaintiff's attorney would do it to me later, just in case we're not around, and there's a collateral estoppel issue at a later date. That was my concern.
Thank you.
So, counsel, we can clear this up really quickly. Are you claiming that all of the damages that you alleged in that the trial court granted you judgment on all of the damages that you alleged in your complaint?
I think at a minimum, we have liability on the head injury.
No, liability, I'm talking about damages.
I don't think a judge can find summary judgment on damages, but we move for summary judgment on liability, and there's no dispute.
That he was injured by this.
Right, he was hit by a falling plank.
Could have been he was dizzy for 15 minutes, and that's $2 of damages, or could have been he was permanently disabled for the rest of his life, which is $3 million. You're not saying that the judge granted you judgment on all of your different claims of damages.
I don't think we can, but you know, now 3211F CPLR, when you're opposing summary judgment, you don't have enough evidence, you tell the judge, this is early, this is premature, they didn't do that. So that's, you know, beyond that, there's no real dispute what happened here. He was hit in the head, he passed out with 2 planks, he lost consciousness.
I feel like there's like a little hesitation on your part. Are you 100% acknowledging that any issue as to liability has to be tried at trial? What his head injuries were, what the extent of his head injuries were, that's something that's going to be decided.
You mean damages?
As to damages, yeah.
I think we want liability as a matter of law, and then let the jury decide damages. Now, just to finish up this point, this
Let me just ask you, if you don't mind, was there an examination? Was there a physical examination? Are all the medical records exchanged and everything?
I don't know. I don't see it in the record. I wasn't representing him at the Supreme Court level. But
okay.
On the issue of one of the primary arguments is that we don't know if there's liability because we don't know what caused the back injury. Graminga, this court decided Graminga 30 years ago. The facts are almost identical to ours, and our facts are better than Graminga. In Graminga, the guy was injured. He didn't even see a doctor for weeks on end. He didn't stopped working, he kept going to work, and he still prevailed on liability on summary judgment. That's our case. Our guy was hit in the head. He did complain of head injuries and neck injuries, so we have that. And, you know, that's enough, and it's not disputed. Unless this court is going to overturn the logic in Graminga, I think this court has to sustain the finding of summary judgment on liability for Sangar, have a trial on damages. Thank you.
Thank you.
Just in 60 seconds, because I think we resolved most of the issues. It's the premature issue, the credibility issue. Vargas against City of New York, 59 AD 3rd 261, First Department, 2009. Similar case to this, where the plaintiff basically said that she was struck by a 9-inch long pipe that fell several floors, and the plaintiff was granted summary judgment at the trial court level. However, in that situation, because the plaintiff didn't seek medical attention until a week after the accident, after her employment terminated, in which she claimed she didn't seek treatment until later because she feared losing her job, the plaintiff testified that the reason why he didn't complain about back injuries, et cetera, is because his boss, Barella, actually said, don't complain. It's similar in this. We're not saying that ultimately the plaintiff wouldn't get Labor Law 240 sometime. We're saying it's premature in this situation. To answer the court's question with regard to medical records, et cetera, no,
there's no doubt that a gravity-related injury, some injury occurred. There's just you're just asking us to clarify that you get to argue that whatever back pain he had was from a ski accident 30 years ago and not from this accident.
And the second point,
we get that.
That's great, but the credibility issue, just as in Vargas, he didn't seek any medical treatment for the head. There's no loss of consciousness. There's nothing. Thank you very much.
The next case is Tsai versus Lowe, and Justice Ung is recused on that matter.
Good afternoon, Your Honors. May it please the court. My name is Song Chen for appellants here. At the pleading stage, the court below dismissed appellant's counterclaims in its entirety, despite the fact that respondent took away appellant's investment and their ownership in the party's joint venture by depriving of appellant's means of paying off the so-called loans, procuring appellant's default in those loans, and thus forfeiting appellant's ownership in the joint venture. appellants never would have provided their money here, 3.5 million, and their labor to form the joint venture with the respondent. They never would have borrowed from respondent over $6 billion short-term loans, which appellants clearly, repeatedly told respondents that they don't have money to pay off such loans. Had the respondent not misrepresented what the joint venture was going to do, had the respondent not agreed to accept any offer above the agreed bottom line price from a third-party buyer to purchase the joint venture's real property, that's very important for appellants. So we make sure respondents repeatedly assure to us they agree upon that. Then we went into this joint venture and provide our money and labor to respondents. The court below dismissed our breach of joint venture agreement on majorly on two grounds. One, statute of frauds.
So let me just ask you, you're saying you have a joint venture, and the joint venture culminates in an operating agreement for the LLC, correct?
That's correct, Your Honor.
But you didn't put in the LLC operating agreement. So it's hard to know on this record what everybody's obligations were. But you are saying in any event that there was a side agreement, other than the operating agreement, by which the plaintiffs agreed to vote their share or their interest, their membership interests, in a certain way, correct?
Yes, Your Honor. First of all, the operating agreement is very basic, and it did not contradict with...
So then we would look to the LLC law, which generally requires something like this to be in writing, correct?
Correct, Your Honor. But
go ahead.
The fraud perpetrator normally will not leave a trace. And in this case,
right, okay. Assume that I agree with you that this is not a sale of real property that is covered under the statute of fraud. It's a voting agreement in a LLC agreement. But my question to you is, can you have an oral voting agreement in an LLC agreement that contradicts the terms of the operating agreement or contradicts the terms of the LLC law?
You are right. If we should, and if we have put in something in writing, there's no case here, there's no tragedy for my client here. That's insane for my client to borrow $6 million, and they told the respondent they cannot pay for that. And they were induced to borrow the loan because the respondent told us that a lot of things. One of the most important things is they are going to do the flip sale. They will, they give us the advance consent of the voting, saying that they will allow us to sell the real property so we can have the proceeds to pay off the so-called loans. By the way, the loan did not come to my client's hands. They went to the...
But let me just ask you this. Even if they foreclose and they take your LLC interest, right? They have to foreclose. They have to do a UCC sale. So you get they have to pay the loans off, and then you get the profit. So what's the problem?
The problem here is, first of all, the respondent has already declared formally by the attorney who we thought our attorney, but actually worked for the respondent. They sent us notice saying that the corporation has foreclosed their option, pursue their option, choose to forfeit our ownership, and now we have been precluded entirely from the corporation. Not only about...
But isn't that what you want? Don't you want out? Don't you want them to pay off their loan and give you whatever, whatever your interest is? That's what I'm trying to figure out. Isn't that what you want right now?
Your Honor, the position...
Don't you want to get out of it?
No, Your Honor, the position the respondent is here that we no longer have the right to claim...
Oh, wait, you're saying the respondent says, I get your interest and you get nothing and you still have to pay off the loan?
That's why they have a case to confirm their position.
Okay.
And
I'll ask your adversary.
And in this case, we cannot participate in the joint venture after they declare they have forfeit all
You want the profits that would be gotten from the increase in value over the last few years. That's what you're trying to get, right?
right. Basically,
Okay, thank you.
thank you, Honor.
You'll have a chance for rebuttal.
Thank you, Honor.
Good afternoon, Your Honor. Stephen Holohan, attorney for the respondent in this brief, in this appeal, rather. I think that this boils down to two identical promissory notes that were executed.
Counsel, why shouldn't we let this case go forward based on the theory that there was an oral agreement specifically to not prevent them from either selling their interest in the LLC or selling the property? Why isn't that a viable claim that should survive your motion to dismiss?
Because the action is based on two promissory notes. The promissory notes are identical. And
They're saying that this agreement was entered into before the promissory notes were ever even agreed to, that the only reason that they agreed to the promissory notes was because your client agreed to not block a potential sale. Otherwise, they never would have entered into the promissory notes. So they're saying it's before the promissory notes.
and that's just revisionist history,
But counsel,
Judge.
why isn't that an issue of fact? You're saying it's revisionist history, but that's why you have a trial or you have a summary judgment motion. That's not a basis for a motion to dismiss.
No, it should be, because subsequent to that alleged oral agreement, they entered into an agreement called the promissory note. And the promissory note says that you can, it reads that you can't modify it other than by writing from the
They're not
parties.
seeking to I'm sorry, go ahead. Go ahead.
But the oral agreement that they allege doesn't modify the note. If they didn't produce somebody who wanted to buy, they would still be liable on the note. So it doesn't modify the note at all. That's what I'm having, that's why I don't understand your argument.
Well, it does, because they're saying they don't have an obligation to pay back.
No, they didn't say
affirmative
they didn't.
defense is that they have a defense to the note based on the oral agreement. Their defense to the note.
Their argument is that you violated your prior contract, the oral contract, to approve any sale. They're not claiming that they have no obligation to pay the note. Their claim is that you violated your oral contract with them to approve a sale or a sale of their interest.
No, they're alleging that that prior agreement precludes them now or stops them from having to pay back the note. That's the actual defense. It's a defense. It's an affirmative defense to paying back the note, saying we don't have an obligation to pay this note. We told you we weren't going to pay the note in the prior agreement, and that would modify the payment terms of the note, which say that it can't be modified. So even
it wouldn't modify. First of all, the note is non-recourse, and it doesn't have a provision that says that there are no offsets, that, and that. It does not have that, right? Two, this is part of the, sort of like a side agreement to the LLC. It's an LLC agreement that you will vote, your client will vote their shares a certain way. It has nothing to do with repayment of the note. It has to do with, they are counterclaiming for your breach not to vote your shares in a certain way that would allow them to repay the note.
And if that were the case, Judge, where is the LLC? Where is the third-party action?
I mean, nobody put it in. I looked at the appeal record myself.
There's no.
Well,
there's
then
no
you
action.
can argue that this is a pre-answer motion to dismiss. We are all required to accept the plaintiff's allegations, unless you have a document, which you didn't put in, that would refute it.
No, but the document that stands in and of itself and for the obligation is the note, is the two promissory notes. That's the agreement they entered into. They had no other written agreement other than that.
Thank you, counsel.
Yes.
Thank you again, Your Honors. Very important facts about the case. Actually, appellants provide $3.5 million in the labor to the joint venture. Joint venture already purchased the $16 million real property, the first step of the intended flip sale. And the respondents, appellants have secured multiple qualified offers, including one $50 million offer from third party to purchase the real property. That circumstance evidence show the respondent never have intention to do the joint venture with us to share the profits. Instead, they procured us, and as we guess, after that, they will do the sale by themselves and take away all of our investment and labor, all the money, everything they promised in this case.
Thank you.
Thank you, Honors.
The next case is People versus Luck.
Good afternoon, Your Honors, and may it please the Court, Jane Merrill on behalf of Mr. Gregory Luck. Mr. Luck was convicted in federal court of conspiracy to commit sex trafficking of a minor. He was subsequently required to register in New York. The Sora court erred in finding this conspiracy offense to be registrable. The question before Your Honors is whether promoting prostitution in the second degree is the state offense most closely analogous to Mr. Luck's crime of conviction. And Your Honors, it is not. Mr. Luck was convicted of conspiracy. The analogous offense to conspiracy to sex traffic a minor is not promoting prostitution, it's conspiracy to promote prostitution. And that's an offense that is not registrable. Your Honor, binding case law from the Supreme Court and the Court of Appeals demands the conclusion that conspiracy is treated in a different way than completed and attempted offenses.
Well, counsel, let me ask you this. North, which seems to be the controlling case in this matter, says offenses, if the offenses overlap, but the foreign offense also criminalizes a conduct not covered under the New York offense. Why doesn't the standard of the North apply in this case?
Your Honor, the standard...
It's a different standard than for enhanced sentencing for second felony.
Yes, Your Honor.
It's a much more lax standard, and you get to look at the underlying allegations. So under the standard as articulated by North, why wouldn't this case fall into that?
Yes, Your Honor, this case actually doesn't fall under that standard. North articulates a three-step analysis for when the court can get to that review of the underlying conduct, and those standards aren't met here. The first requirement is that the board, the court, identify the analogous New York State offense, and that wasn't done here.
Well, why didn't the board case summary establish that defendant committed the New York offense of second degree promoting prostitution based on the allegations in that board case summary? Why wasn't that sufficient?
Your Honor, it's not that it wasn't established, it's that the court is not authorized to look to the underlying conduct here. This is an elements-based analysis. That's what the statute says, and that's
why is it, you just said, why is it an elements case analysis?
I'm sorry, I didn't hear you.
Why is it an elements case analysis?
Yes, Your Honor. The statute says that it's registrable when the foreign offense has all of the required elements of the New York State offense, and North expounds on that. It introduces some ability to look to the underlying conduct, but only when there is the analogous offense that has been identified, and secondly, when the offenses don't overlap in a particular way. And that particular way, which is what the court in Blue got wrong, is that when the foreign offense criminalizes more conduct than the New York State offense, that's when this...
You're saying we shouldn't follow the Blue analysis, and that standard in North should not even apply in this case.
The standard in North should apply in this case. The court should identify the analogous offense, and that wasn't done here. The analogous offense is not registrable. Even if this court accepts that this was the analogous offense, a comparison of the elements doesn't result in the conclusion here that the foreign offense covers more conduct than the New York State offense.
Why does it have to cover more conduct? That's what I'm not understanding.
Yes, Your Honor, that's what's set out in North, that in order to look at the underlying conduct. That is the only situation that North authorizes a look to the underlying conduct.
And where's the language in North that says that?
Yes, Your Honor.
And why is Blue wrong?
Yes, Your Honor. Sorry, I do have it here in North, but...
You know what, I'll let you address it on rebuttal since...
Thank you, Your
Have some
Honor.
time to take a
And I'll address Blue at that time as well. Thank you.
May it please the court, ADA Andrew Luzidi is appearing under the supervision of ADA Stephanie Nelson pursuant to the practice order of the First Department Appellate Division for Respondent. Good afternoon, Your Honors, and may it please the court. The appellate just mentioned briefly a moment ago, People versus Blue. I want to jump on this case briefly because People versus Blue had very similar circumstances to the events in this particular case, and it arrived at the conclusion that, conspiracy to sex traffic minors matches with promoting prostitution under New York law. Defense counsel has stated several times in her brief that Blue was wrong, but Blue was not wrong. In fact, the Court of Appeals of New York, which made a tribunal of justices, did not grant leave to appeal. They decided this together because they realized that there was nothing legally wrong with People versus Blue. The elements of People versus Blue match up well with the events here in this case. The defendant was convicted in federal court of conspiracy to sexually traffic minors. This is a 16-year-old girl, and now must register under New York law. SORA was designed specifically for individuals such as the defendant. He admitted, as I just stated, that he participated in a conspiracy to sexually traffic a minor, the 16-year-old girl. SORA is a prophylactic preventative measure. It is not punitive in nature. The defendant must register under New York law in order to protect the community from individuals such as the defendant. If Your Honors don't have any questions, then I respectfully ask that you affirm the lower court's decision.
Any questions? Okay, thank you very much.
Thank you.
Yes, thank you. As to Your Honor's earlier question about where in North, I'm looking on page 753. It's at the bottom of the paragraph beginning considering its context. The court states, in circumstances where the offenses overlap, but the foreign offense also criminalizes conduct not covered under the New York offense, the board must review the conduct underlying the foreign conviction.
So the board must review the conduct?
Yes.
So why shouldn't the board review why shouldn't we consider the board's review of the conduct in this case?
Your Honor, respectfully, the foreign offense does not cover more conduct here. These are two totally distinct offenses. It's not correct that SORA was designed for cases like these, and that's evidenced by the act itself, which subjects to registration attempts and completed offenses, not conspiracies. And beyond that, Your Honor, the foreign offense doesn't criminalize more conduct here.
Counsel, didn't the defendant in the federal matter admit, he said, I recruited one individual who I knew was younger than the age of 18 to engage in prostitution?
Yes, Your Honor. That was
factually, doesn't that establish promoting prostitution in the second degree in the New York law?
Your Honor, this is an elements-based analysis, and that portion of Mr. Luck's allocution was not related to the elements, or rather not unrelated, but it was distinct from the elements, and this is an elements-based analysis. So while there is that allocution, this inquiry is really controlled by the elements, which are set out by the prosecutor in this case.
Thank you very much.
Thank you.
Milosec versus Exxon Mobil.
Good afternoon, Your Honors. Michael Fay for the appellants. This appeal, Your Honors.
So why do you think plaintiffs have the ability to commence this action asserting a single cause of action challenging the CRP? Because 805, the way I read it, really only allows two people, the record holders or the committee holders with record holders' approval, to challenge the CRP, right?
With all due respect, Your Honor, that's not what it says. Now,
What does it say? Tell me.
it says that the required holders or the holder committee with required holder approval have the right, comma, on behalf of all holders. If you look at no action clauses, like the one that the Court of Appeals dealt with in Quadrant, that
Different, very different. Quadrant dealt with a situation where the no action clause there only spoke of the indentured, and the Court of Appeals says it didn't use the word security, so that allows the plaintiff to pursue security claims or common law claims. In this case here, that's not the situation. This case here is your complaint doesn't allege breach of fiduciary duty or other claims that are common law right claims. It's alleging a single cause of action, which is the CRP agreement. That's the difference between Quantro.
But then what is...
Did you follow what I had to just say?
Well, I understand. That's the difference in the holding in Quantro. But look at the provision in Quantro. In the provision in Quantro, there's no on behalf of all holders. What does that mean? I mean, that reading, Your Honor, reads on behalf of all holders out of this provision, this sentence in section 8.5.
Yeah, it means that the record holders are controlling this aspect, and it doesn't allow anybody else who's not a record holder, because the holder committee, if you read the definition of the holder committee, really is powerless, because they don't really get to do anything, right?
Correct.
So the record holders are key, and if you have a complaint, or if the holders have a complaint with respect to the record holders, just like in the RMBS cases, they go after the trustee saying you didn't do what you're supposed to do, right?
So, but that doesn't make sense, because what this says...
I didn't say it made sense. I'm just saying, I'm just reading what it says.
Well, we have to figure out what's the most reasonable interpretation here.
Well, okay, so what possible class action could there be for breach of the CSP?
You could represent all the holders claiming they did something wrong, that Exxon did something wrong, that they...
No, you can, but you don't need to represent that's exactly right. But you don't need to do a class action lawsuit for that. So again, there isn't a reason to have that as interpreted as only a class action, because there's no class action lawsuit for violation of the agreement. That's my whole point. A class action lawsuit is something different.
Of course there is, Your Honor. There's class action.
Breach of the agreement.
There are class action lawsuits all the time for breaches of indenture agreements, where we're going to say, I represent all the holders, right? I represent all the EVR holders, and we're going to sue. Otherwise, that provision makes no sense. First of all, another thing to keep in mind, the required holders under Section 7.2 of this agreement, they can agree with Exxon to amend this agreement.
That's the whole point. I mean, when you say, then tell me then what your interpretation on behalf of holders mean. You mean that means that any holder of the certificate, any holder of the security can just challenge the CRP?
Yes, because this provision says that there's a limitation with respect to the required holders in the holder committee only where someone is suing on behalf of all holders. It says that. That provision, if they wanted to bar my clients from bringing this action, they shouldn't have put that provision in there. It should have just said...
I'm sorry, go ahead.
Right? I mean, you don't need that provision. You could have just said, notwithstanding anything contrary in this agreement, the required holders or the holder committee with required holder approval are the only party who can bring an action.
No, but isn't the sort of how the agreement works is you either choose. You choose that you're going to agree to the agreement and agree that once this later payment comes, only if enough people, enough shareholders are upset with it, do you get a lawsuit. Or if you don't like that, you don't agree to the agreement and you go to your rights as a dissenting shareholder. That's the way the agreement is structured. That makes sense.
That's not what the agreement says, Your Honor. I mean, that's not what it says. And as the Court of Appeals said in Quadrant, that's what controls.
So is it your position that 8.05 does not affect your client's right to sue at all and only affects who has the authority to bring an action on behalf of all holders.
Correct. It actually says that, Your Honor, on behalf of all holders, which is exactly the language that you find in Federal Rule of Civil Procedure 23 or CPLR Section 901 that deal with class actions. There's a provision here that says...
So each shareholder could bring their own action? Thousands of shareholders could each bring thousands of actions?
Your Honor, it's a contract.
Under the agreement?
Yes.
Yeah, but you know
Saying
what?
that that's how they set it up, so there could be thousands of lawsuits.
Your Honor, under an indenture, under the indenture in quadrant, under Section 316B of the Trust Indenture Act, same thing happens. Every single holder of a security under a indenture has the right to bring an individual action.
Yeah, but that was only on securities, not under the indenture. Under the indenture, only the trustee was permitted to bring that action.
That's not correct, Your Honor.
I read Quantrill up and down, left and right.
Under the Trust Indenture Act, Section 316B, every individual holder of a security has a right to sue for principal and interest. We cite that in our brief.
I'm not disagreeing with you. I'm just saying that under Quantrill, they're not allowed to sue under the indenture. They brought their breach of fiduciary duty claims. They brought a whole host of claims, everything that you're saying, but not touching the indenture. That's what the Court of Appeals said. Let me ask you this question. When you focus on behalf of all holders, that's your line where you're saying if anything short of that, anything that's short of that allows plaintiffs, your clients, to bring a lawsuit challenging the CRP, right?
Correct.
So how do you then explain then, for the avoidance of doubt, the final clause of that sentence that says, and no individual holder or other group of holders will be entitled to exercise such rights. So if there was any ambiguity with what you just said about all, on behalf of all holders, that last tagline cuts against that, don't you think?
Your Honor, such rights refers back to what is being said, which is right, okay? The first word is right, all right? On behalf of all holders, by virtue of any provision in this agreement to institute a proceeding. A right to institute a proceeding on behalf of all holders. That's a class action.
Okay, let's hear from opposing counsel, and you have time for rebuttal. Thank you.
Good afternoon, Your Honors. May it please the Court. Andrew Ditchfield from Davis Polk on behalf of the respondents. This agreement works exactly as your questions reflect how it's supposed to work.
Well, counsel, what does that quote mean? On behalf of all holders. Why is it in there if it doesn't mean what your opponent says it means?
Because I think you need to take a little bit of a step back and look at the entire provision as a whole, Section 8.5 as a whole.
Before you take a step back, could you answer my colleague's question and tell us how you interpret those 5 words?
Yeah, the right that's held by the required holders is a right to exercise. It held on behalf of all holders. If you look at Section 8.05, what Section 8.05 acknowledges is that this is an agreement between Exxon Mobil.
Counsel, would you have gotten to the place that you want it to be to prevent all these lawsuits without that clause? In other words, was that necessary for your purposes?
I don't know whether it's necessary for purposes, but I think
that's the point. So the point is that it's added in there. It must mean something. And the way
means,
you're asking us to interpret it is you're asking us to excise that clause.
Not at all, Your Honor. What that clause is reflecting is that in a provision that's specifying that in an agreement between Exxon Mobil and an escrow agent that confers rights on behalf of third parties like appellants here, there is a limitation on who can sue on behalf of that right. And the right is held by the required holders on behalf of all holders. And that's clarified at the end. If there's any ambiguity around the purpose of that phrase, it's clarified at the end by the statement that says no individual holder can exercise such rights. The right is not the right to sue on behalf of all holders. The right is to initiate or prosecute an action. Now, appellants have made the argument that this language, this on behalf of all holders language, is parallel to the CPLR 901 or Federal Rule of Civil Procedure 23, but it's in fact not, okay? Both of those provisions say that the ability to bring a lawsuit to sue in a representative capacity on behalf of all holders. It's at the end. It's not in the middle of the provision like this one is. It does different work. It's a clarification that the required holders, notwithstanding the fact that this agreement confers rights on third-party beneficiaries, the required holders holding a right on behalf of all holders can bring a lawsuit, and they're the only ones that are allowed to bring a lawsuit. And that's exactly what the provision, what the Court of Appeals in Quadrant's reasoning was all about.
So are you saying if you gave up your right for to individually sue, then you would not have accepted the agreement and you would have been a dissenting shareholder?
That's exactly right. There are multiple mechanisms here, going all the way back to February of 2017, to object to this transaction and the outcome of this transaction.
But counsel, what they're doing is that they're not objecting to the transaction overall. They're objecting to the way that the valuation was made, right? Which occurred after the transaction closed. There's no way to dissent now.
Well, if that's the case, Your Honor, then we just need to look to the decision from the Yukon Court of Appeals in February of 2020, which actually decided what the valuation, what the proper valuation was, and it was the $45 per share of Exxon stock, plus the contingent resource payment that was actually paid, which is roughly about $5. So that court, with all of the information that's alleged in this complaint, found exactly what what these shareholders were paid.
If that were the case, then what you would be doing here is essentially arguing that this should be dismissed because it's already been decided by that case. But that's different from saying that the plaintiffs here don't have standing, which is what you're arguing. And I still have trouble understanding how you get to the plaintiffs having no standing. Certainly the plaintiffs have no standing to sue on behalf of all holders, but what is it that deprives them of their right to sue, since under Quadrant, no action clauses have to be very narrowly construed?
I agree, Your Honor, that under Quadrant, no action clauses have to be narrowly construed based on the language that the parties used. And the
So what is the narrow construction that you're giving us here? Because it seems to me that your construction ignores on behalf of all holders.
It doesn't ignore on behalf of all holders, Your Honor. The work of on behalf of all holders is to reflect the fact that the required holders hold the ability to exercise the right, and they hold it on behalf of all holders. What this does not say—
You could have easily have imparted that in the contract without that clause, right? That clause just complicates things.
Well, it may complicate things, Your Honor,
but
we
wouldn't be here without that clause, right?
Well, I actually, respectfully, Your Honor, I disagree, because the history of the litigation that's occurred since 2017 has been one where Mr. Milosec, on behalf of appellants, Mr. Milosec, one of the appellants, challenged the transaction initially. He didn't challenge the second iteration of the transaction. In fact, the Court of Appeals of Yukon found that he endorsed it. He's now waited 4 years. He didn't exercise the alternative dispute resolution mechanism, which was an alternative basis for dismissing the case below. And so what we're here now with is somebody who decided to sit on their hands in the face of the ability either to dissent or to pursue alternative dispute resolution, and in the face of a provision that says that no individual holder has the ability to exercise a right.
And there is no—
I have a question. I'm sorry, go ahead.
And there is no giving up any common law right here, because as I read Quadrant, it's just 805 just says you can't pursue us under the— you have to— if you're going to challenge the CRP agreement, you got to follow 8.05. You want to commence in any other action asserting other causes of action, have at it at that point. And this complaint, unless I'm reading the wrong complaint, only asserts one single cause of action, that's challenging the CRP.
One single cause of action, breach of contract.
And on behalf of holders, sort of frame of— it's almost like a term of art as you're describing it. You know, it's upon behalf of all holders, their rights in terms of with respect to this agreement. It's not actually saying that if you don't have all the holders, then the ones who are outside of it can sue or at least bring a lawsuit under the challenging the CRP.
I agree, Your Honor, and there's no deprivation of the ability to bring a lawsuit under this agreement.
Counsel, plaintiff says that no action, that they have never seen a no action clause that includes the phrase on behalf of all holders. I didn't see anything in your papers that identifies any case with a no action clause that includes that provision. Did I miss something? Are there any such cases that say, that include a no action clause with that language in it?
Your Honor, I'm not aware of any, but I don't think that it matters, because
So what does that mean here? Why was it necessary to include it?
because the drafters use the phrase in a provision that talks about the conference of third-party beneficiary rights to make clear that notwithstanding that the required holders were the only ones who could exercise the right to bring a lawsuit. It's not to bring a lawsuit on behalf of all holders. It's that they have the right. The language says only the required holders will have the right. Then it sets apart by commas, on behalf of all holders, and then there's a bunch of language, to institute any action or proceeding at law or in equity. The right is the ability to institute or any action or proceeding.
On behalf of all holders?
No.
Why not? Then what is it doing that?
Because if you wanted to have that reading of the argument of the agreement, you would have to move the offset phrase on behalf of all holders to the end of that provision, so that it would say, we'll have the right to institute any action or proceeding at law or in equity on behalf of all holders, or to institute a class action. There are much simpler ways, going back to Your Honor's question, there are much cleaner ways to write this so that it indicated that it was intended to limit intended to limit this solely to the ability to bring a class action. And frankly, under this framework, the contingent resources payment agreement, Your Honor, going back to your question of are there any other no action clauses like this, I frankly have never come across what's called a contingent resource payment agreement. It's similar to something like a contingent value right or something like that.
But I don't really think that that's the question. The question isn't what the suit is about. The question is who is standing to bring a suit challenging any part of this contract.
Correct, Your Honor, but to the point about why is this language included in here and it may not appear in other no action clauses, what Quadrant teaches us is that when there's an omission, like the phrase or the securities from the no action provision that was at issue in Quadrant, when you omit that piece of information, then you can look to other similar clauses to understand whether that omission is material. But here, this is a standalone sui generis provision. Now, as I said,
I'm going to end it at that unless you have any further questions. Okay, thank you very much.
Thank you very much for your time and questions, Your Honor.
Your Honor, you're right. I mean, this provision has to have some meaning. And to say that what it means is that the required holders, when they sue, will be representing all the holders, that can't possibly be true. First of all, we don't even know who the required holders are. The required holders are 25% of the EVR holders. We don't even know who they are. Second of all, under Section 7.2 of this agreement, the required holders can engage in a new agreement with Exxon, and this is exact language, that adversely affects the holders. So under Section 7.2 of this agreement—
Counsel, if that's the case, then these holders then have an action against the required holders then, right? I mean, we have all these legion of RMBS cases where they've challenged the trustees in terms of their, lack of how they saw,
But Your Honor,
aggressiveness, right?
What we're trying to do is come up with the most reasonable interpretation of this.
Why do we need to come up with, if I read it and I don't find an ambiguity, then there's no.
What does on behalf of all holders mean, Your Honor? I mean, literally, what does that mean? Why is it here? It's not in the provision that was at issue in Quadrant. It's not in the provision that's at issue in any other case.
You're saying that phrase empowers your client to individually bring a claim.
What that phrase does, Your Honor, is limit the scope of this sentence. It makes this sentence about representative or class actions. That's the only reason.
Without saying anything about class action.
That language.
Right? There's no language in there that says you can only bring a class action if this group says it. That doesn't say. We all agree. It doesn't say that.
Read Federal Rule of Civil Procedure 23, Your Honor.
I mean, come on. No, that's a completely different
They use the same language, Your Honor. When we talk about a class action, in Section 901 of the CPL law, we say an action brought on behalf of all members,
Thank
all
you very much.
holders.
Thank you. The last case today, Cullity versus Posner.
If it pleases the court, my name is Doug Barracks. I represent Lisa Cullity, the plaintiff appellant. The primary issue here is really, it's a review of the facts. There were numerous checks paid between the parties over a period of about 6 or 7 years for the appeal in question. The lower court, unfortunately, her decision, the lower judge's decision, was rather sparse on her reasoning and how she arrived at the conclusions. That's really broken down into 3 parts. Number 1 is which checks that were paid by the father to Cullity constituted the alleged loan. Number 2 is which checks should be paid by Cullity to the father as credited towards her. The first problem that was encountered was that the lower judge did not specify which checks paid by Cullity to Posner she used in her chart. The lower court did use check numbers and as well as a brief description of some of the memos. So the facts and the record did allow enough to back in. That was contained in the facts under chart section 1. I don't believe there's any dispute in that. Without that chart, I would submit that a remand is the only potential option because without that basic information, it's impossible to determine which checks were counted and which were not. The second issue we have on the facts is how much Posner paid to Cullity. That is broken down also into 3 sections. The undisputed amounts, there were a couple of minor checks, I think $600 or $700. We don't need to spend time on those today. The big issues were the checks made payable to cash. There were a number of checks where those checks payable to cash were clearly deposited.
Why shouldn't we defer to the trial judge on those kinds of issues?
Well, that's a very good question, and this is one of the errors made by the lower court. The lower court said numerous times that to submit summaries of each of the positions as to what was paid and so forth, and there was supposed to be a follow-up conference in August of 2019. That's on the last day of the trial. Presumably, there would be any kind of addressing of this issue at that conference. For whatever reasons that are not clear in the record, the judge never scheduled this final conference, and shortly after that, about 3 or 4 months after that, COVID kicked in. Normal practice is often if a trial judge does not schedule a conference, you could certainly raise that to the judge's attention, but unfortunately the next step was the trial judge emailing saying, I'm done with the decision. So what the court should have done was schedule this conference at some point or say that the decision is pending and we need to address these. Either way, the trial judge did say that if she does this, she does not interested in matching checks and deposits, but unfortunately, it is respectfully submitted, that was the trial judge's job. She was supposed to match the checks for cash into that. However, that's only about $40,000. The other big one is the amount of checks that paid by Cullity to Posner as to which ones were credited and which ones were not. There, we have undisputed checks and so forth. However, the lower court erred by not using the father's, Posner's, Chase bank account number that were clearly listed on all the checks. In chart, I believe 3C, it lists every check paid to Chase Home Finance. I believe chart 3B is Chase Home Equity. Those were interchangeable names. I believe there may have been a name change, but they accepted both. Each and every check had the Posner's home equity line of credit number. It's that long number. If you look on pages, I believe 944 to 955 or so of the record, all of the father's checks had his account number on it. So each and every one of those checks with that account number should have been credited towards any repayment. So this is simply a math error. This is a factual determination. Had the lower court allowed that conference to go forward, but for COVID, it most likely would have, this could have been addressed in the lower court. So that's why it wasn't addressed there. We have the other secondary, well, not secondary issue, but whether or not there was a contract between these two people. It is a father-daughter relationship, and I would ask that the court consider there were two disputed amounts. Number one was the premarital money, which was stated down to the details, signed by parties for about $40,000 or so. For the larger amount...
I'm going to let you finish up on rebuttal, okay, since you have another minute for rebuttal.
It please the court, my name is Gary Grafman. I'm counsel for the Posners, who are the respondents in this case. In this case, the elements of the contract were clearly established by the evidence which demonstrated that there was an oral agreement between the Posners wherein they would give money to Ms. Cullity and she would pay it back. First, you have Mr. Posner, who testified at the trial, which the judge saw and was able to assess the credibility of the witnesses. He testified clearly and unambiguously that there was an arrangement with his daughter where he would give her money, and during each conversation, he would say to her, I'm giving you the money, Lisa, but I'm loaning you the money, you're going to pay.
Counsel, let me just ask you, although you do admit that there was a $3,100 mistake, correct?
There was...
It was a script,
yes,
an
there
ad,
were two
right.
checks.
Okay.
One
So
was...
that covers basically a lot of what counsel was just arguing, that there was a mistake in adding, and you agree $3,100 has to be reduced.
Correct. Those two checks, we, on the record, said that there was one for 50.
All right, so that's, assuming that that takes care of the discrepancy in the numbers.
Correct.
Is everything else credibility issue, basically?
I'm sorry?
Is most of the other arguments just a credibility
Yes, a credibility issue, and you had Ms. Cullity testify at various contradictions. First, that there wasn't a loan at all, that there was, the repayments that she was making were not to repay a loan, but were for investments that her father was making for her. She testified there wasn't a loan because it was forgiven, even though there was no documentation, and it was her obligation to demonstrate that. She testified there was a loan, but she paid it back. So, I mean, she testified pretty much, it was a jumble of contradictions. So the lower court, if the lower court took her at her word that there was no loan and that there was no repayment of a loan, therefore, she should have gotten no credit. But the court did determine that there were some checks that had indicia of a loan. What were those checks? The checks that were made out to Fred Posner, the checks that were made out with the memo said for Fred Posner, and the checks that she wrote, partial repayment of loan to dad, or something to that effect. The court found, as a factual finder, that those checks should be given credit to her. The other checks were either some of them for her own mortgage that she wanted credit for, some were never deposited, and there was no endorsement by Fred Posner. We don't know where those checks were. She never demonstrated where they were. There was a whole host of other checks. So the court gave her credit for those checks, in our opinion, charitably, that the court found some indicia of repayment. And that's all she should be entitled to. With regard to her burden to demonstrate repayment, there's another significant issue, which is she's never asserted that as an affirmative defense in this case. And under the law, and we cite case law on that point, she waived that claim. So we would contend she should be satisfied with the fact she got $41,000 as a credit, given that she never even asserted an affirmative defense to that. With regard to these IOUs that she had, I mean, those were clearly, if you look at the documentation in the context, expressions that the father was going to give her money. This had nothing to do with the loans. This is just that you need money for your lawyer, Bryce, you need money for a visa, I'm going to give you. So he used colloquially, so I owe you this money. One of the documents that they're relying on was for a stock transaction where he did say, if you give me some money, I'll put it into the iFlow stock. And when he sold it, he said, okay, I sold it, I owe you, I think it was $4,500 or whatever it was. But these are separate and apart. And she never sued on any of them, which we contend he paid her the iFlow money. He gave her the money for the lawyers and the Disney tickets. She never proved otherwise. But these had, to be clear, these had nothing to do with any money she gave him, and he was expecting a repayment. So that's a red herring in this case. So we would ask your honors to affirm the lower court and end this 12-year-old case in which the daughter it was commenced by the daughter suing her elderly parents, and they were able to be given judgment on the counterclaim.
Thank you.
Otherwise, we rely on our brief. Thank you.
Very briefly, the counsel correctly pointed out that Lisa Collity's testimony, it was all over the place. She said there were loans, no loans, repaid, et cetera. So was the father's. He had IOUs signed by him saying, I owe my daughter $40,000, but testified that those were merely memos to themselves. It's submitted that neither party had a clear understanding of what they were doing, and there was no meeting of the minds. No meeting of the minds, no contract, no loan. Gift is the only possibility because these were essentially, here's the money, pay me back whenever you can, I won't come after you. Number two, that the loans don't equal payment. It seems that the father's position was that I'm not going to acknowledge any repayment, you prove it. In his pleadings, he didn't even say how much he lent or how much was owed. It was silent throughout the trial. He constantly was saying, I'm not accepting anything. It was only after the trial judge acknowledged the $40,000 did he acknowledge that. This is certainly not a loan in that sense. So, thank you.
Thank you, counsel.
That's it. Out.